Welcome to Chapter 3 in your Employment Law class. In Chapter 3, you're going to learn about Title VII of the Civil Rights Act of 1964. Introducing you to the Civil Rights Act and providing the structure of the Act and the historical background, who it applies to, is a large part of the law when it comes to protecting employees from discrimination. After you finish this chapter, you should have a good kind of overview of the structure and the specifics of Title VII and why that law was enacted. It's important to be aware of, the practical approach to understanding these concepts. And instead of learning just a whole bunch of rules for the exam, I think it's important for you to actually learn how to avoid liability in a workplace setting for workplace discrimination. About the reality of how this stuff applies in real life and what this really looks like. It's important that this resonates with you so that you can really understand what it means and what it kind of looks like. I mean, before you even got into this employment law class, you probably already knew what kind of workplace discrimination was basically prohibited on a very general level. If we were sitting in the same room together and I asked you what kind of discrimination was not okay or illegal, it'd be pretty quick that a lot of people would name the categories like race, gender, religion, etc., that kind of stuff. You generally know to include, sexual harassment, discrimination, discrimination against people with disabilities. A lot of people know this, and yet employment law litigation is still an area that is contested regularly. People know this, and employment law is still alive and well in the court system. Most of the cases of discrimination that people are, brought to court for and found liable today are not stemming from the employer being overtly discriminatory or intentionally malicious. I mean, there are some of those cases still, of course, but they've increased, and those have even increased in the last few years. But instead, a lot of this litigation comes from policies or responses based on society notions about certain groups in which many people grew up with or have obtained, stereotypes through like media, social media or something, and they manifest in the workplace. So simply knowing the basic requirements of the law isn't enough today. It's important that, as you go into your future careers and future workplace, knowing you shouldn't discriminate isn't enough. Understanding, that you should be a good person and not discriminate and stuff like that is what most people know, and yet it still happens anyway. It's not just something awful that people do and they miss the subtleties that are engaged in that create a source of employer liability. So it's important to keep in mind, where this kind of came from through the civil rights movement and what it actually looks like in everyday life today. So before we get really too far into the chapter, let's go through your learning objectives really quick for this chapter. So we're going to look at the history leading up to the Civil Rights Act, examples of the ways that certain groups were treated before the Civil Rights Act, what kind of things are prohibited by the Civil Rights Act, in Title VII, who is covered by Title VII, who's not, and how a Title VII claim is filed and proceeds through the process. If a Title VII claimant is able to proceed after receiving a no reasonable cause finding, distinguishing among the various types of ADR options by the EEOC, and then the other statutes that apply in the employment law context, the post-Civil War statutes that still apply today, and what management tips, there are to ensure that you have compliance with Title VII. So going back to the history lesson, the statutory basis of where Title VII came from in the Civil Rights Act of 1964. This Civil Rights Act of 1964 came out of the civil rights movement in history in the United States, and the part that applies to your learning in this course of employment law is known as Title VII of the Civil Rights Act, that makes it unlawful for an employer to fail or refuse to hire or discharge an individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of their race, color, religion, sex, or national origin. or to limit, segregate, or classify employees or applicants for employment in a way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. This is, quoted directly from the Civil Rights Act. Under the Civil Rights Act, this is an example of a 1961 employment want ad that was before Title VII. So this was, an exhibit taken from an actual newspaper of how these want ads were kind of classified in ways that would not be allowed to be classified today. But this was like a real life example from 1961. Historically, the focus initially in the civil rights movement was about race, a centuries-long struggle for equality, and the focus was on race. But the Civil Rights Act, after it was passed, had more broad coverage and included other categories, the basis of race, color, gender, national origin, religion, to be protected against in employment context, in housing, education, government, public accommodations, government funds, all those kind of things. And in 1964, Title VII is that employment law section of the Civil Rights Act. And so it prohibits workplace discrimination on the basis of these protected classes, race, color, gender, religion, national origin. And it applies to the spectrum of employment relationships. So we're talking about people that are applying, applicants, hiring, discharge, compensation while employed, terms of employment, conditions or privileges of employment, and, through the end of terminating an employment relationship. It's also important to note that states have similar laws in Title VII. For example, we have, additional protections to Title VII that have been expanded through Supreme Court decisions and also through state statutes and court decisions as well. There have been amendments to the Civil Rights Act. Most notably, they have been a long time ago. So, the Civil Rights Act last year has celebrated its anniversary, 60th anniversary. And in 1972, 1978, 1991, the Civil Rights Act was amended. There is argument to be made that it's probably time for another amendment to the Civil Rights Act. We just haven't seen that come through Congress yet. But there have definitely been proposals of things that should be included in, whatever the next amendment might be that kind of encompass and codify some of the more recent Supreme Court decisions or the directions that some of the states have gone. And of course, there's been some landmark, decisions through the court system or agency decisions as well that have also changed the interpretation and structure of how it applies in the law to employment contexts in Title VII. So let's look at how Title VII has kind of evolved over the years. Again, it's been over 60 years since the passing of the Civil Rights Act of 1964. So early emphasis, was a lot on hiring related cases, giving people that employment opportunity, that chance for the job. More recent concerns in cases have been on promotion or compensation or other employment benefits. Harassment law has developed through the evolution of Title VII. Religion claims have changed in the post 9/11 world. There are retaliation claims on the rise. Interpretation of sex discrimination started out as very different than it is today, because today's considerations include issues related to sexual orientation and transgender individuals, in addition to concerns for and controversy surrounding the concerns for diversity, equity, and inclusion cases. There's really been a broadened understanding of at-will exceptions generally found at common law through Title VII. And again, more of a recent focus, kind of the way that the litigation is going under these kind of cases is about, bias in the workplace, unconscious bias even, or pay gaps that might exist. There's AI context in the future, how AI, interprets things and analyzes things. We have issues related to the post-COVID world, the post-pandemic world that we're in, and some of the things that impacted employment law issues. And of course, there's always going to be different EEOC initiatives coming through the pipeline. So these are just some statistics about the kinds of charges that were filed with the EEOC in 2021, which is relatively recent history, and the percentages of the types of cases that were found. So I want to draw your attention to this illustration, this exhibit in your book about cages as you go through this section of the text. And it kind of illustrates how most of us look at things on this like microscopic level. We tend to see only the situation in front of us, and we don't always give enough thought to the larger picture in which it fits. And it's this larger picture in which we actually operate in. You know, this one law, considering when they're enacting legislation, the courts consider interpreting the law and deciding the cases, and thus the one employer should consider when developing workplace policies and responding to situations. Often a situation in and of itself may seem to us to have little or no significance, along with simply not being award of issues that might seem to have little to do with our individual lives or experience. We're therefore not operating with the same facts. Why are they whining about this? Why can't they just go along? Why are they being so sensitive? Why do they have to make such a big deal of something? But sometimes we can miss the larger picture and how this situation fits into it. So like this birdcage example, each individual thing in and of itself may not be a big deal, but you put them together and the picture is revealed of a very different reality for someone dealing with these wires. One individual wire, oh, why couldn't the bird fly around it? But if you widen your gaze and you see all these different wires interconnected, it makes this impenetrable cage. So some of the situations you see in the following chapters are the wires that Title VII and other protective legislation try to eradicate in an effort to break down the seemingly impenetrable, invisible barriers that sometimes have been erected around issues of race and gender and all these manifestations, disabilities, ethnicity, religion, age, family, medical history, genetic information for generations. So as you go through these cases information, think not only about the micro picture of what's going on in front of you, but also think about the larger picture that it creates and fits into. Because sometimes what makes little sense in one setting can make better sense in another. And I have if you are looking at the PowerPoint slides separately, I have a link to the full article that comes from this source. So let's look at the structure of Title VII. It applies to promote equal opportunity in the fundamentals of this employment relationship. So an employer can't discriminate on the basis of race, color, gender, which includes sexual harassment, pregnancy, sexual orientation, gender identity. That should be two separate buttons, sorry, pregnancy and then sexual orientation separately, and gender identity, religion, and national origin. In making decisions regarding hiring, firing, think about the timeline of employee and employer relationship, discipline, compensation, benefits, classification, other terms and conditions of employment, all the way through the ending of the employment relationship. So who has to comply? Title VII. Employers engaged in interstate commerce, if they have someone who has 15 or more employees for working at their business, labor organizations that exist to deal with employers concerning labor issues, and employment agencies that procure employees for employers or opportunities to work for employees. So think about temp agencies, stuff like that. So employees covered by Title VII, undocumented workers. So employment discrimination against undocumented workers is illegal. The EEOC is not going to ask someone's immigration status when they're a claimant claiming that they've been discriminated against. There's, of course, still a policy debate regarding that interplay of immigration and employment regulations. If you remember back to your legal environment case, there's standing debates on whether someone has standing if they're not depending on their citizenship status, and these workers may not be eligible for certain forms of relief, such as reinstatement and back pay, as it's been ruled in the Hoffman case. So there's some distinctions to be made, in particular for workers that are not citizens of the United States, undocumented workers. And there's also employees that are not covered by Title VII. So think about really small businesses, employers that have less than 15 employees, might be exceptions to this rule for compliance. a non-U.S. citizen that's employed outside the United States, U.S. citizens employed elsewhere if local law specifically forbids compliance, outside of the United States. Employees not covered by Title VII would also be employees of religious institutions or associations that are hired to perform work connected to those religious activities. Remember, we talked about, bona fide occupational qualifications and things like that that are distinctively intentionally discriminatory because of whatever standard. So that can apply to religious employees. Members of communist organizations, Native American employees on Native American reservations have, different laws that they comply with in tribal law. And also, of course, I have a note right here just that you remember that independent contractors are not employees, so therefore they're not going to be subject to this kind of employment law. Okay, so non-federal employees who believe they've experienced employment discrimination can file a charge or claim with the EEOC. Federal employees are covered by Title VII, but simply follow a different procedure. So an employee filing such a claim is called a claimant or a charging party. The person who brings the claim, the respondent, the responding party, that's the person who is being accused or alleged that they have violated Title VII. It's typically, the employer in that employer-employment relationship. The EEOC investigator, that's the employee of the EEOC, the administrative agency that reviews the Title VII complaint to see if it has merit and, meets those requirements. There are record keeping and reporting requirements in order to file these claims. The requirements under Title VII that certain documents must be maintained and periodically reported to the EEOC. And so those documents, are like personnel records related to a charge be kept until the final disposition of that claim. And there's also other EEOC records that need to be kept. So when it comes to statute of limitations, we're talking a pretty brief statute of limitations, and this is important for these claims to have the appropriate evidence and witnesses and things in place to prove or disprove a claim. So sometimes these claims can drag on for years. In certain situations, if a case has dragged on for like 10 years, sometimes it's about whether you have all the right documentation, you still have the evidence and witnesses and that kind of thing. So the limitations period between the alleged act and filing a claim is what we're talking about with statute of limitations. And, if someone is a non-federal government employee, the claim must be filed within 180 days of the discriminatory event. For federal employees, claims must be filed with their employing agency within 45 days of the event. Also, we have paycheck accrual rule in the Lilly Ledbetter Fair Pay Act. And so in that law, the 180-day statute of limitations begins to run all over again every time a paycheck is issued based on pay discrimination. So that's, the reason for that fairly short statute of limitations in Title VII is an attempt to ensure that these necessary parties and witnesses are still available. The events are not so far gone that people don't really remember things accurately or we lose evidence. And it's important that violations of Title VII are also brought to the EEOC's attention quickly because, its own investigation or by information provided employees meeting their record keeping and reporting requirements. Those requirements under Title VII that certain documents be maintained periodically reported to the EEOC is really important. Okay, so most states have, their own fair employment practice laws that track similarly to Title VII. They also have their own state and local enforcement agencies for employment discrimination claims. Most of these agencies contract with the EEOC to act as a 706 agency. It's a state agency that handles EEOC claims under a work sharing agreement with the EEOC. It's important to remember that similar but independent state laws exist. So those coverage and procedure things might vary from Title VII to deal with the claim. And of course, the general preference is that we have situations, under these kind of cases, the attempt is made to reach agreement through like discussion, negotiation, without having to resort to litigation. Conciliating the claims is that attempt to reach agreement on a claim through that discussion or negotiation. The EEOC process Starts within 10 days the employee filing a claim with the EEOC. The EEOC serves notice of the charge to the employer. Remember that person's the respondent or the responding party, alleged to have violated Title VII, and the respondent must then respond to the claim. That Title VII, is the law that they are claiming has been violated, and it's a separate offense for employers to retaliate against an employee under Title VII. Remember, if someone brings a claim, regardless of whether they win or lose that Title VII claim, it is still a separate offense for them to have had some negative employment consequence as a retaliation for the claim that they've brought under Title VII. So the EEOC's approach to mediation has been pretty aggressive in the last, recent decades. There's a lot of backlog of cases and claims that have gone on way too long. So the EEOC has adopted some important steps to try to kind of streamline their case handling process to help make it more efficient, more effective, less time consuming for claimants. So primary along these steps is the adoption of mediation as an alternative to full-blown investigation and litigation. So, the mediator seeks to facilitate this agreement, but they can't force outcomes on the parties. The parties still need to voluntarily agree to whatever the mediated agreement is, if they can come to one, but they're sent to mediation to choose to participate in that process. There are, a lot of discrimination claims that are sent back to the employer for mediation to try to come to some kind of resolution, and there are universal mediation agreements to encourage the employer and the employee to participate in this process. Of course, again, it's a voluntary process, it's confidential, and the settlement agreements that they reach are going to be binding on the parties that voluntarily agree to those terms. So in cases where the parties refuse to mediate or the mediation is not successful in coming to, an agreement, the charge can be referred back to the EEOC for handling. The EEOC investigates the complaint. They'll go talk to the employer, talk to the employee, and whatever other witnesses and evidence, viewing documents, that kind of thing. And if they determine reasonable cause or no reasonable cause, if there's no reasonable cause, the claimant's given a dismissal notice of rights known as a right to sue letter, and they can file a suit on their own against the employer in federal court within 90 days. If reasonable cause is found, the parties can meet with the EEOC investigator to, again, conciliate, settle the claim. They can, try to negotiate another deal, even if mediation was unsuccessful before. If there's no settlement, the EEOC can file suit on behalf of the claimant, on behalf of the employee in federal court. And if it gets to this point, there's a really high rate of success in court from the EEOC. If by the time they get to that point, they win most of the time. So in situations where no conciliation is reached and the EEOC has filed a civil action in federal district court, the employee can take the case to court seeking judicial review. If the EEOC originally found no cause and issued the complaining party the right to sue letter, the employee can go directly to court, judicial review. Title VII requires that courts accord the EEOC decisions de novo review, which means they look at it from scratch, a brand new look, no presumptions based on whatever findings the agency had. In recent years, mandatory arbitration agreements as mentioned earlier, they've gained tremendously in popularity. So previously confined almost exclusively to like union situations, maybe security industry, these agreements are entered into by employees as a condition of their employment when they are hired. And it stipulates that workplace disputes, including workplace discrimination claims in violation of Title VII, will be disposed of by submitting them to arbitration rather than the EEOC or courts. And so because of these, mandatory arbitration clauses, it's become very popular with employees as an alternative to this more drawn out EEOC and court process. It's less expensive, it can be faster. An arbitrator has a final decision, in the case, rather than that trying to reach that voluntary agreement. The agency can still bring an independent claim on the employee's behalf, but the traditional EEOC hostility is not a barrier to the agency's mission, and it varies between some of the politics involved. So over the years, there's been some recent Supreme Court cases that kind of have decided important issues in this area, holding that mandatory arbitration clauses requiring arbitration of workplace claims are enforceable, and that an employee subject to mandatory arbitration agreement, since the EEOC is not party to the agreement doesn't prevent the EEOC from pursuing victim-specific relief in court as an enforcement of the action. And then, of course, changes in law in 2021, sex-based claims were removed from arbitration requirements and can't be enforced in mandatory arbitration agreements or clauses in employment contracts. Okay, so this exhibit illustrates the Reconstruction Civil Rights Acts. We're looking at the post-Civil War statutes, what they are, what they do. We've been discussing these discrimination claims under Title VII of the Civil Rights Act of 1964, but this Civil Rights Act wasn't the first piece of legislation that was aimed at prohibiting racial discrimination. These other laws came into play way before that and are still used today. So we have to make sure that we address and include, the mention of these statutory provisions and understand the full range of potential liability of discrimination under these kind of lawsuits. So the three laws, again, are post-Civil War era laws. So you can look at the date they were passed: 1866, 1871, 1871. And these are the three main acts that were in the pre-Title VII era. So initially, starting with passing of Section 1981, it made all African Americans born in the United States citizens and ensured them at least the right to make and enforce contracts the same as enjoyed by white citizens. In 1868, Congress passed the 14th Amendment to make laws applicable to the states, dictating that no state shall make or enforce any law that shall abridge the privileges or immunities of the citizens of the United States, or deprive any person of life, liberty, or property without due process of law, or deny any person within its jurisdiction equal protection of the laws. In 1871, realizing that the ongoing violent resistance to the slaves by whites, often in positions of power in groups like the Ku Klux Klan, Congress passed this act in 1871, as well as the color of state law legislation. So when considering these statutes, the statute of limitations for these post-Civil War statutes is longer than that of Title VII. So Title VII's basic statute of limitations, is about 180 days from the precipitating event. The Supreme Court has ruled that the statute of limitations on race cases under Section 1981 is 4 years. In addition, the damages under Section 1981 don't have the same limits that those under Title VII have, the caps. And so by and large, most of these cases brought under these statutes as opposed to Title VII, either because the claimant was outside the statute of limitations deadline, or maybe the claimant involves a government employer. So it's important to note that discrimination claims have to be proved just like any other lawsuit. One of the prevalent misconceptions that a lot of people have about Title VII is that all an employee must do is file a claim and the employer is going to be liable for this discrimination that's being alleged. Discrimination claims under Title VII and other employment discrimination legislation, they have to be proved just like any other lawsuit. So the employee's got to offer evidence and support the claim and meet the prima facie case and meet all the elements that are there. They still have that burden of proof. And so a lot of times managers don't discipline or even terminate employees with Title VII protection because they're scared of being sued. Title VII is not a job guarantee just because someone's part of a protected class. Instead, it requires employers to provide them with equal employment opportunity, including termination if it's called for. No more, no less. No one can stop an employee who feels discrimination has occurred from suing. And that's why the best defense for an employer that they can ever have is to engage in consistency and even-handedness that makes for a less desirable target to have justifiable decisions to defend against a claim if they're ever sued. You got to have a good system and follow through with it, consistently treating employees fairly and equitably, hiring the best person for the job, promoting people that deserve it, and such, because those are justifiable behaviors. So, of course, just like with the other chapters, we have some management tips for how to take this information that you've learned in this chapter and apply it, in a career setting. So the management tips that I have for you in this chapter, make sure that the employees understand, what Title VII really is. Who does it apply to? How does it apply? What does it require? How can employees' actions bring about liability for the employer? What kind of behavior is okay and not okay? What kind of actions will be looked at in a Title VII proceeding? All employees have a right to a workplace free of illegal discrimination, and the employer won't allow Title VII violations. Make sure those policies are in place and that they're followed through with. An employer will be proactive in prevention and diligent in including all employees in that decision-making process. And so in summary for Chapter 3, remember that Title VII prohibits employers, unions, labor management committees, employment agencies from discriminating on any aspect of employment on the basis of race, color, religion, gender, national origin. Title VII has, this full statutory scheme, including federal agency, application with the EEOC, administrative structure for bringing workplace discrimination claims. In certain situations, claimants can have access to a jury trial. The claims can be reviewed through judicial review after they've exhausted the administrative remedies. And don't forget there's the post-Civil War statutes that also apply into this area for protection against discrimination with longer statute of limitations and without the damage caps that Title VII comes with. And of course, from the employer's perspective, the best defense is a good offense. Having good, strong policies of non-discrimination, hiring the best person based on things that are not that have anything to do with these immutable characteristics that are protected classes under Title VII, making sure that the message is out at all levels of management and leadership, that discrimination won't be tolerated, having these really good policies that are not just in existence and in writing, but they're consistently and appropriately enforced, and continue with updated training so that people are aware of how these issues happen and how to make sure that they don't and they're dealt with appropriately. And then, of course, using the law strategically. So compliance with Title VII can help workplace productivity benefit, and unlawful discrimination cases are very costly to profits. By avoiding litigation, employers can keep those profits where they belong instead of having to pay out a lot of lawsuits because of bad decisions, bad behavior, bad policies, that kind of stuff.